State of Florida is now in session. The Honorable John M. Harris, Judge, presiding. All persons having business before this court are on here. Give attention, you will be heard. God save the United States of America, this state of Florida, and this honorable court. Please be seated.
For some state.
Some state. Florida, New Hampshire, somewhere.
All right, good morning. Welcome to oral argument session here at the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Harris. I'll be presiding over the arguments here this morning. I'm joined on the panel by Judge Lambert and Judge McIver. A couple housekeeping matters. If you have any cell phone, other noise-making devices, please make sure that they are silenced or turned off at this point so that the proceedings are not interrupted. We are being, for whatever it's worth, live streamed, recorded and live streamed on YouTube, so just keep that in mind. Each side's going to get 20 minutes for their argument. The appellant can reserve as much of that as you would like for a rebuttal. Unless you tell me otherwise, I will set that rebuttal at 5 minutes. If you want something different than that, please just let me know. All right, this panel has two cases we're going to handle this morning. The first one is case 23-2554, Bonnie Lee Mickler versus Rebecca Triplett and Lucille Harnage. At this time, appellant, if you are ready, you may proceed.
Good morning, Your Honor. May it please the Court, Kevin Franz, on behalf of Bonnie Lee Mickler, I respectfully request the 5 minutes for rebuttal.
Yes, sir.
Mickler was denied a fair trial based on the heart of this case, as mentioned by the trial court judge, which was causation. And we request that the court reverse and remand for a new trial. So the trial court granted a directed verdict on causation. And there's two starting points to really focus on this. One is that directed verdicts in negligence cases, especially as to causation, are rarely appropriate. And they're treated with special caution because it's for the function of the jury to weigh this evidence, especially on causation. The second is that this court reviews it de novo with taking the evidence in the light most favorable to the non-moving party with every reasonable inference in her favor, in which case this is Ms. Mickler. This court said in Green Shields in 2021, any evidence supporting a possible verdict for the non-moving party means that the directed verdict is improper. So there's a plethora of evidence in this case to show that it was error to grant the directed verdict. First, we have a 2009 auto accident where the plaintiff was diagnosed with a cervical sprain at the ER. Then we have a 2017 head-on collision at 75 miles per hour combined, where Dr. Zagardi, the chiropractor, testified that the plaintiff had neck pain radiating down her arm, muscle spasms, disc misalignment that never realigned, and a diagnosis with a sprain. She was discharged in 2017, but then came back a couple months later in August saying she had more pain.
Let me ask you this, counsel. If for some reason we want to agree with Traver's opinion from the 6th DCA and Lancheros, is that basically on point and should be reversed just on that issue and we don't have to talk about anything else?
Yes, absolutely. The Lancheros case it's shockingly similarly factual. In that case, the defendant admitted fault just like we did in this case.
What's the significance in Lancheros, the plaintiff waiting 18 days to seek treatment, and in this case it was the same day? Is there any significance?
There's no significance at all because the expert witness for the defense in Lancheros testified that the plaintiff may have suffered a sprain or strain, and this is critical, that the plaintiff's chiropractic treatment 18 days later was, not might be, was related to the accident. And
so you're a victim of realignment, I guess, as I see this, because this was a 5th DCA case, and if we didn't push that one out the door over to Orlando, he would have wrote that for us.
Yes, Your Honor, is correct. This is a 6th DCA, so of course it's not binding, but I would point out that the Lancheros decision relied directly on this court's decision in Thinge, which is another case very, very similar. In fact, in Thinge, which was in 2017, the trial court struck, if I'm correct, all of the defense experts on causation.
Well, it's kind of ironic because one of our former judges over there at the Sixth, one of the first opinions out of the Sixth was, we don't have to listen to anything that the Fifth or the Second wrote, so, we're on our own now, so. Which they're right, but I always enjoy the irony when I listen to some of these cases.
But it is telling that the Lancheros court cited to Thinge, which was, again, an auto accident case where there was no testimony from the defense in terms of experts because the expert witnesses were excluded. And there was a granting of a directed verdict for the plaintiff on causation, and this court reversed, saying the jury can believe or disbelieve whatever testimony from the experts that they want to believe. And there's a lot of reasons for that, whether there's pre-existing injuries, evidence of degeneration, if there's lack of candor from the plaintiff in terms of the history, which we have here. It's outlined in the brief ad nauseum.
But didn't they kind of do what they should do in a scenario? I'm talking about your opponent at trial, the plaintiff's attorneys. If you just let the jury answer the first question yes or no, and they say no causation, defense verdict. There's some case law that says, well, if there's some treatment initially after the accident, that should be compensable whether there's a permanent injury or causation. I wrote an opinion long ago in Schwartz and Walmart, a case with the 8-ounce beanbag or whatever it was, that basically said, if you would have done that, we'd look at you differently, but when you ask the jury to answer question one and they answer that no, you can't come back as the plaintiff on appeal and say, hey, that ain't right. You shouldn't have given that the option to do that. Isn't that what your colleagues on the other side did here?
Well, they're incorrect, and the judge's ruling is incorrect, and here's why. Generally, Your Honor is correct. However, there are about 8 exceptions to the rule that a plaintiff would ordinarily get initial treatment. And
that generally I'm correct. Now and then I'm correct. All right.
Well, there's exceptions, and those are if there's pre-existing injuries, a jury can certainly find that all of the injuries claimed are pre-existing. Number 2, if there's conflicting medical evidence, which in this case we have based on a slew of what happened to the plaintiff before this accident. Number 3, if there's evidence that impeaches the doctor's testimony. Number 4, if there's lack of candor by the plaintiff in terms of the prior medical history. In fact, Dr. Fox testified in this case that some of what plaintiff told him didn't match up with the records. And his testimony is that he bases his diagnosis on sort of looking at the entire puzzle, which isn't just one examination, but it's also what the plaintiff tells them.
What's the time frame between this accident and the 2009? Here's one of my observations throughout all this is, not just this case, but a lot of cases, is, okay, you ask a person that, I may not remember what I told the doctor 10 years ago when I was treated for some, my neck was bothering me, and then when I don't remember that, and the CME guy gets it and says, didn't tell me about in 2004 that, your neck bothered you for 8 weeks, and therefore issue a fact for the jury. Is there any leeway for any of that?
Well, the problem is in this case we're talking about, she did have a 2009 accident, but really a lot of what plaintiff didn't disclose, or there may have been issues about complete disclosure, was the 2017 accident to 2019, which is not a great deal of time. And what's important about the 2017 accident is that she was discharged by Dr. Zaccardi in June of 2017 saying, okay, you don't have to come back unless you're in pain. She comes back in 2 months later. And throughout this time, up until essentially the day of the 2019 accident, she's undergoing therapeutic massages, which Dr. Zaccardi said that was a good idea. And Dr. Fox said that is something that can treat what we're dealing with here, which is muscle spasms, ligament damage in terms of a sprain or strain. So there is, this issue of causation happens in most auto accident cases that go to trial, including this one. And that's why we cited 5 or 6 cases, including those from this court, that said, look, this is just not something that the trial court judge should take away from the jury, because it's a jury question. And causation is one of the 4 elements. It's a threshold element to prove that the plaintiff's cause of action.
Going back to the lack of candor, is it your position that that lack of candor is only in her omitting certain facts, or did she affirmatively misstate facts, or is it both?
It's both. She omitted facts, and she testified that she, at one point, that she was fully recovered, but then she changed her mind and said, well, I do have some of the same symptoms that are there. But the critical testimony in this case really concerns the prior degenerative issues, and that's from Dr. Fox, who said, look, she has an underlying chronic, long-standing condition probably starting in 2009, but certainly going up to 2017, and sometimes, look, there's just a low-level issue that you just deal with over a period of time. This isn't shocking testimony because most people have low-level issues that they sort of deal with over time. But that's what he said, and he said it's something that just continues on, that may wax and wane, and you deal with it as needed. So the judge could not take away and say, look, absolutely there is no possible way that a jury could find that all of her injuries predate the accident. And that was an error.
So she may have gone to see the same doctor regardless of the 2019 accident at issue? I mean, isn't that basically the scenario, saying you have a pre-existing scenario, back condition, whatever condition, and over the course of your life you may seek treatment for that. Here there's evidence like, well, she's seeking treatment because she had this accident. It seems like your posture would have to be that this would have been treatment she would have received regardless of the accident, therefore causation should be a matter for the jury.
And that is exactly what the jury instructions tell the jury. You have to determine whether or not the damages that the plaintiff is seeking. For example, if the plaintiff gets a surgery, a year after the 2019 accident, the jury has to determine, well, what was the cause of the zeller? Was it this 2019 accident where it was a glancing blow at 11 miles per hour where Dr. Zeller testified the forces were the equivalent to sneezing or sitting down? Or was this related to a 75 mile per hour head-on collision that occurred just 2 years earlier? That's why we have all these cases. That's what the jury is there to determine. And this really, as I mentioned, the Lancheros case is directly on point factually. And I outlined that in the brief. I don't need to waste the court's time with that. So I'd like to move on to the second issue, which is actually directly related to the first issue, and that's the jury instruction that was given on the directed verdict. The trial court abused its discretion by issuing an inadequate instruction. The law in Florida from Albin versus Union Carbide, 2015 Florida Supreme Court, is that reversal is required where a jury might reasonably have been misled, regardless of whether it actually has been misled. So the directed verdict in this case, undisputedly, was as to just some injury related to the sprain or strain. That was less than 1% of the damages that they requested for past medicals, which was $113,000. So the instruction that we objected to was a standard instruction that, and I'm paraphrasing, said the negligence of Mickler was a legal cause of damage to Triplet. Triplet's therefore entitled to recover from Mickler for the damage, as is shown by the greater weight of the evidence to have been caused by Mickler. Now the notes on that instruction, which is standard instruction 401.13D, says that should be given when the sole issue to be determined is damages. But that wasn't remotely the sole issue. The vast majority, again, over 99% of the damages they claimed didn't go to the sprain or strain. It went to surgeries. So it was an inadequate instruction.
Was it incorrect? It seems your argument is there was a better instruction, and this one gave too much, didn't give enough direction to the jury as to what the judge was really telling them on the issue of causation vis-a-vis all the damages that are being sought.
Absolutely. How can a jury understand that causation was only found as to the care spot costs if they weren't told that? So the instruction was there was abuse of discretion in only issuing that instruction because it was inadequate. There was a subsequent abuse of discretion in not issuing the instruction that we wanted, which was to tell for the judge to tell the jury exactly what the judge ruled.
Well, if the judge would have given your instruction, would that resolve the first issue that you raised on the DV?
Oh, absolutely not, because they are two separate issues. We're arguing that the judge absolutely should not have taken causation, period, away from the jury. If the judge had given the instruction that we asked, then I wouldn't be here arguing this issue. But the jury could certainly might have been misled to think, oh, the judge is telling us that Mickler caused her all of her injuries. Why? Because the judge didn't tell us that Mickler only caused a small percentage of her injuries. And it is an abuse of discretion in not giving us, the instruction that we requested here, because, and this again is under Aubin versus Carbide, it's an accurate statement of the law, which is what the judge found as a matter of law. The facts in this case supported giving our instruction because the facts were the judge only found the DV as to a very minute portion of the case, and it was necessary for the jury to properly resolve the issues in this case. The last issue that I have, Your Honor, kind of ties into all of this again, and the judge said twice in this case, this was the heart of the case. And this was that Triplett changed and altered and doctored the smoking gun record on causation. This was a 6-page final evaluation on June 27th, 2017.
They made a demonstrative aid out of that 6-page record, right? They never sought to admit it.
They never sought to admit it, but demonstrative aids, of course, cannot mislead the jury. The jury has to be, you cannot deceive the jury as to the force and credibility of evidence, whether it be by an actual piece of evidence or a demonstrative aid. And that's what this did, because what this did was so critical. The plaintiff's position in this case was that all of her damages resolved as of June 27, 2017. And anything else was Mickler's responsibility. But the medical record in this case that was changed around and deleted and omitted portions clearly shows that she still had ongoing issues after that time. And that goes to the defense's position that...
So you mean let's go back in the old days here when you had the poster board and you used the highlighting thing. You couldn't have gone up and say, let's look at this record and let me write the good stuff. I mean, they wouldn't say good stuff, but let me show you the stuff that indicates whatever you want in it. You don't have to say, here, I'm going to put up the whole 6 pages. You could have just selectively taken it out. I mean, it seems your concern is that it looked like a record. I mean, the record was already in. They just took the stuff that they like, which is what lawyers do, saying, here, look at what was said in this record that supports our position, and the jury can take the whole record back and look at it and read it, and right?
And what occurred here was far more severe. And the reason that we know it isn't from my opinion or anyone else's opinion other than the judge sitting in the courtroom who saw this. And he said, and he said this right after it was shown, quote, I will say that if I had known what the plaintiff was putting up, what it is, I would have sustained an objection to it. Even if there wasn't an objection, I would have not allowed it in.
But despite that angst that the judge is displaying or commenting on, he thought the best route was to issue a curative instruction, a strong curative instruction. Why isn't that a discretionary call that we defer to? Because he's reading the room, so to speak.
Because not all curative instructions work. There's a plethora of cases that say, look, you have to look at this on a case-by-case basis.
Some do, right?
Some
That's
do.
the whole purpose of it,
Some
right?
do, but I'll explain to Your Honor why this one didn't work. Number one, again,
We lost.
and I apologize for going over my time. I want to answer the
Much
court's
time.
questions. This was, again, as the judge said twice, the heart of the case. There was extreme prejudice in seeing what was portrayed as the final record that she was fully healed. This is something the jury cannot unsee. It was highlighted right for them in front
How
of their
long was
face.
the record shown to the jury?
I'm sorry, Your Honor.
How long was the record shown?
Probably about 2 pages of transcript, which I don't know what that translates to, but it doesn't really make
Then the
it.
judge directed the plaintiff to take it down, and then the jury never saw it again, I assume.
Right, but this is one of those things that because this was essentially the smoking gun of the case, this is not something that the jury could unsee. And this was made a big issue in closing. The entire closing argument is based on what caused all of plaintiff's $113,000 in damages. And the big fight was she fully healed in 2017 or was she not? So this was a critical piece of evidence. Judge, Your Honor, I've exceeded my initial time.
You have about a minute 36 remaining.
Thank you, Your Honor.
Yes, sir.
May it please the court.
Yes, sir.
Aaron Sprague on behalf of Appley, Ms. Dagley Triplett. I want to take the issues in the same order that my colleague took them, in which begins with the directed verdict. And the first thing that I think this court has to take into account when we're analyzing the directed verdict is that it was limited in nature. And the reason why that's important is because in their papers, and again in their arguments just now, we have an expansion of the matters, evidence, and issue that are being dragged in to oppose the directed verdict, which aren't germane. The directed verdict was granted only as to that injury which Dr. Fox testified was accident-related, which was a temporary sprain-strain aggravation of pre-existing conditions. That and that only. We're not talking about disc herniations or facet injuries or any other neurological problems. And we heard from the appellant just now about how, surgery may not have happened, or pain management may not have happened, or it could be related to, pain management could be related to other things, or surgery could be related to other things. Surgery, pain management, facet injuries, disc herniations were not the subject of the directed verdict.
What was the chiropractic expense total that was at issue that you got the directed verdict for?
Your Honor, in both of the appellant's and Appley's papers, the court commented that what it was granting the directed verdict on was the care spot visit, which was immediately after, within hours after the accident.
How much?
Your Honor, I don't remember off the top of my head. I can.
$50,000?
No, Your Honor, it was.
$280-something dollars?
If memory serves, it was somewhere in the neighborhood of $1,000. And I don't remember if that's correct or not. I can check the record.
So you got so it was $1,000 you wanted a directed verdict on, and that became the tail that wagged the dog here.
Your Honor,
That was certainly the sense of the trial, right? I mean, why is that a critical thing to a plaintiff to get a directed verdict on $1,000 damage part of that aspect of the claim here, other than it can be used as a springboard, which Lancheros is concerned about, and I think Judge Traver commented about how it was unsurprising what then happened after in that trial.
Your Honor, in answer to that question, I don't believe it is the tail that wags the dog, simply because it took away the jury's ability to render a defense verdict. And that in itself is significant. When the jury is then deciding about extent, that's more favorable to the plaintiff than having to worry about a zero verdict in its entirety.
Didn't I talk about that in that Schwartz opinion that I wrote as to the process to address the claim for damage, for the initial care and treatment damages, even if the answer to question one on the negligence case is no on the verdict?
Your Honor, I believe that.
I'll answer for you. I did.
Yeah, that would be one way to deal with it. I think that
would have probably been the best route to take, because it basically, the issue of causation was in dispute here. But if you want to still get the $1,000, use your number for a second, there could have been a second aspect in that verdict form that says, even if you answer number one no, do you believe it's reasonable for, or that could have been the directed verdict by the judge, saying, okay, if it comes back no on question one, we will still agree to award X dollars for that care that both the CME and your doctors say are reasonable immediately after the accident.
So
That
whether,
would certainly have been what I would perceive here in this case to be the more generous route to take here to address everybody's concerns so that the trial would be cleaner and you wouldn't be here on this issue.
whether the issue of the immediate post-accident medical bills and expenses was decided after a jury rendered a verdict or before a jury rendered a verdict, we're still taking that issue away from the...
But I mean, what your opposing counsel is saying is then you guys double down, saying, all right, look, you got this, let's have a clear jury instruction so it's, the jury can look back at that and look at that when they're trying to sift through the evidence. You have a more generic instruction, not incorrect, I'll give you that, but, it kind of tilts the fairness of the trial, I think, is the concern on the opposing party. It's saying, look, if you win because the jury finds causation and damages. But, when a judge comes and directs a verdict, that has a significance to a jury.
Your Honor, first dealing...
That'll be been avoided on on $1,000 out of 100,000+ in past medicals.
On the issue of the jury instruction, I think Your Honor is exactly correct, that it was not incorrect. And what the defense has failed to take into account in their papers and in their arguments to this court is that the law is clear that you have to look at the instructions as a whole. And the instructions that were given for 1.2, for 1.18, for 1.13 made clear that the extent of the injuries were at issue and that the jury was only to award those damages that were caused by the accident. There was no risk that a reasonable jury, hearing the instruction as a whole, could have determined that they were to award all of the plaintiff's injuries. That's simply not within what happened in those jury instructions. I think that there are times, and this I think goes to the other aspect that Your Honor raised, where taking an issue away from a jury is appropriate at the outset. And that's why directed verdicts are part of the rules of civil procedure.
Sure, if your client lost an arm in the accident and that would be a permanent injury, that wouldn't be something you would have the jury address. That would be a proper directive. And obviously that's graphic. But yeah, I agree with the concept of, some things are clear. The jury can't say, well, you lost an arm in the accident, you had 2 arms before, not permanent.
Right,
Obviously.
And I would argue that that when a directed verdict is appropriate depends on the state of the evidence as to the issue, not necessarily as to the extent of the injury at issue. And in this case, there was no evidence that would have allowed a jury to disregard Dr. Fox's opinion under Wald.
Tell me how you distinguished Traver's opinion in Lancheros.
Yes, okay, there's 3 ways in which Lancheros is distinguishable. First of all, if you reading the facts of Lancheros, the plaintiff in Lancheros did not seek treatment immediately after the injury. They waited 18 days, and then only after the initial soreness from the injury resolved. And then they went back to the same level of care that they were receiving before. That is quite clearly not what happened in this case. We sought...
Is it a fact question, though? I mean, yes, it may be a different scope of a fact question, but it's still a fact question, and that was the reason for the Lancheros opinion, correct?
I believe that...
In other words, are you really distinguishing that if you're just saying their fact question was more serious than our fact question?
Now I understand Your Honor's question. No, that's not what I'm saying. What I'm saying is that the fact pattern in Lancheros raised an issue of fact for the jury, whereas a different fact pattern in our case does not. And the distinguishing factor there is the care spot visit. The care spot visit, which we've heard nothing about from my colleague on the other side of the table, is Immediately after the accident, she receives a diagnosis of sprain strain, and the CME doctor says, I agree with that diagnosis.
Didn't your client go to Haiti the next day or something like that?
Right. Now,
Okay, so, and how long was she in Haiti? Did they have it, what did the record indicate?
the record would indicate, and I believe it was over a week, and Your Honor,
Okay, so if she didn't happen to go to Care Spot that first day because she's getting ready to go to, and she you know, lived with the, whatever was the pain immediately after the accident, she went to Haiti and then came back after her trip and saw the Care Spot doctor, for lack of a better term, then it would, I mean, as what Judge McIver, and I agree with what he's saying, it seems to me, because your lady went right away as opposed to this person in Lancheros or Burke going 18 days later, that's somehow distinguishing, even though the CME doctor in your case and that case, at the end of the day, conceded that the post-accident treatment was related to the crash. In other words, get paid, you should get reimbursed those bills for seeing the doctor there, just like you asked to be done here. And I'm failing to see, I mean, if you want to say I think Lancheros is wrong because for whatever reason, and obviously we're not bound by it, but I'm struggling to figure out how that's so distinguishable because you went on day 1 as opposed to day 18.
well, Your Honor, the distinguishing factor, I think, again, lies also in the fact that the Lancheros plaintiff did not seek treatment until after the initial soreness from the injury had resolved. The fact that we sought treatment on day 1 not only indicates that there was an accident-related injury, it goes to the pain that she was experiencing at the time. Whereas in Lancheros, it was much more at issue whether what was being, the pain that was, for which treatment was being sought 18 days later was related
distinction
to...
without a difference. What does it matter that in Lancheros he didn't seek treatment until his pain had gone away?
Because under those facts, Your Honor, then at the point in time in which he does seek treatment, it's much more of a fact question as to whether he's seeking treatment for something that's pre-existing because he went back to the same doctor for the same level of care after the accident-related injury had resolved, or whether what he was seeking treatment for was related to the accident.
Well, what about a plaintiff who's in an accident, doesn't believe that they have sustained any injury, then a few days later they're starting to develop pain in their neck and the back and they go? I mean, and then the plaintiff's treating physician and the CME saying, well, you know, that's a reasonable thing to do if you're having pain a few days after the accident to go seek treatment. Those are reasonable medical bills. That's fair. I mean, I'm struggling with the distinction that you're trying to make in the context of what Chief Judge Traver at the 6th says in his opinion, saying, you know, that's for the jury to decide as to whether it's related or not.
Well, Your Honor,
For the judge to decide. Why would a judge decide that? I mean, you know, we can have our own views about why judges do many things here. Obviously, as appellate judge, we do that about trial judges all the time. But, you know, it seemed like that's an easy call just to saying the jury will figure it out. And then you can always file something after the fact. I mean, after your verdict, right?
Your Honor, with respect to cases in which treatment is delayed for whatever reason for a period of time, again, I mean, I would agree with Your Honor that would be a much closer call under Lancheros, but that's not the facts of this case. When you have a diagnosis that's given on day 1, within hours of the accident, and the CME doctor agrees with that diagnosis of a sprain strain, taking into account whatever pre-existing injuries may or may not have existed at the time, then I think that takes us outside the ambit of Lancheros factually. I think there's other...
The facts are different in the two cases. If the facts are different, what's your opinion? Did Lancheros get it right on their case? Is it rightly decided?
In my humble opinion, Your Honor, I believe Lancheros is wrongly decided because Lancheros doesn't decide the issue within the ambit of Wald, which is the Supreme Court case, which I believe controls. And I think it speaks in generalities which go outside of what the Supreme Court states the analysis should be. Now, I believe also our facts are different than Wald, or than Lancheros, But I believe that Lancheros is distinguishable for two other reasons. First is,
Well, I mean, so if the CME in this case said absolutely no reason for her to have gone to, your client to have gone to the chiropractor, what the name of the care spot?
CareSpot's not the chiropractor, Your Honor, but
Care spot, absolutely no reason to have gone there, then you would agree your directed verdict would.
we wouldn't have moved for a directed verdict.
All right. So then, if I then jump back to what Traver's writing about in Lancheros, he says, he basically said the jury could have completely disbelieved basically the CME in that case.
Right.
And why couldn't, other than you don't agree with what Traver wrote, let's assume for the sake of our oral argument today, we do, not just because he used to be here, but we do, then what's the difference?
Because under Wald, the jury's only at liberty to
Under who?
Wald v.
I
Granger.
said under law. Okay, I'm sorry, Wald, W-A-L-D. Okay, yeah.
The jury's only at liberty to disregard Dr. Fox's opinions if they have an evidentiary basis to do so. And in this case, there was no evidentiary basis to disregard Dr. Fox's opinions. Certainly not the pre-existing injuries, because those were taken into account by his opinions. And as far as the lack of candor goes, number one, the plaintiff or the defense points to differences about who knew what about prior accidents, but it's undisputed that Dr. Fox knew about both prior accidents. So those differences don't affect his opinions. And as to the alleged lack of candor to Dr. Fox himself, number one, that's really not a fair characterization of her testimony or Dr. Fox's testimony. We laid out in our paper, certainly Dr. Fox didn't believe she was not being candid. And inasmuch as that's taken into account at all, that's concerning a facet injury and the response to a facet injection. It has nothing to do with a myofascial sprain strain. In this case, unlike Lancheros, there's no evidentiary basis on which Dr. Fox's opinions can be disregarded. Now, if it's all right, I'd like to move on to, I think we've talked about the jury instruction issue. I'd like to move on to the issue of the medical record and the demonstrative aid and the mistrial.
It'll help you, I'm with you on that one.
Okay. So then returning to the directed verdict, I think that this case needs to be decided under Wald. And that's the analytical.
I mean, they might not be, but
Don't assume that we are, just
yeah,
because he said he is.
they usually don't agree with much of anything I say. Especially Harris.
That is the Supreme Court case that controls. What we have here is an opinion that was rendered multiple times in response to the questioning of their own attorneys, of their own CME expert, that the CareSpot diagnosis was correct. It took into account the pre-existing injuries, and he opined that those were aggravated by the accident at issue. So there was no evidentiary basis to disregard that. This case is not Lancheros for the reasons I mentioned. Plus, there's another distinguishing factor for Lancheros and Thinge. In both of those cases, if you look at what was said in Lancheros and in Thinge, the opinion is equivocal. It's a backup opinion that kind of gets stated as a byline to what is really the main opinion of the expert. In Lancheros, the expert comes in and says no permanent injury, but at most, she may have a sprain strain. In this case, Dr. Fox was much more clear. It wasn't a byline. It wasn't a fallback opinion. It wasn't an equivocation. It wasn't giving the plaintiff the benefit of the doubt. It was a line of questioning carefully developed by the defense over several questions in direct examination. This was their theory of the case. This was their one causation doctor. And they called him up and they asked him, Okay, you've had all of the facts about pre-existing injuries. What do you think about this care spot diagnosis? I agree. It was care spot got it right, spray and strain. And then again, a couple of pages later, it's 1246 of the record. Care spot got it right, spray and strain. Then 1256, 1257 of the record. Well, we've got all of this evidence of degeneration. What does that tell you? Well, it tells me that, she has this degenerative condition. It's triggered by the accident, which causes spray and strain, for which she seeks treatment. That was all on their direct examination. For them to then come in and disavow that and say, oh, no. That wasn't what we were trying to say. We were trying to say that all of her injuries related to pre-existing conditions simply can't be squared with the transcript of Dr. Fox's testimony. Dr. Fox was clear, unequivocal. There was no evidentiary basis to disregard his testimony, and the judgment should be affirmed.
All right, thanks, sir. All right, about a minute and a half left.
I'd like to make 5 quick points. Wald is irrelevant. That case dealt with permanent injury, permanency, which is not what we're dealing with, and factually it's completely distinguishable. Second, in Lancheros, the key testimony from the CME doctor was that the chiropractic treatment was necessarily related to the accident, which the court said the jury could disregard that. In our case, we had Dr. Fox saying, you know what? Yes, spray and strain was diagnosed, but she's had these problems dating back to 2009. It's a jury question. Number 3, my colleague said that this was My colleague said this was only related to Dr. Fox, but that's inaccurate. Page 1395, the directed verdict by plaintiffs said, for that reason, the only evidence in this case, the only medical causation evidence in this case through our experts, meaning the plaintiffs, through the only medical doctor that the defense hired, Dr. Fox, is that she suffers an injury as a result of the 2009 accident. So all of the doctors, it's important for this court to look at all of the doctors' testimony and how it was impeached and how she didn't give the information necessary for them to reach their conclusions. Next, the critical reason, and we're talking, Your Honor, Judge Lambert, about $299. The critical reason they wanted to get that was as a springboard to get $113,000 in medical expenses. They asked for $113,000. That's what they asked for. That's what they asked for in closing, and that's to the penny what they got. It bled into future medical expenses. It bled into pain and suffering as well. That is what deprived the defense of a fair trial. Like Your Honor said, Judge Lambert, they could move for an additor for $299 at the end of the case, but it wouldn't have taken a threshold issue away from the juror. And looking at the instructions as a whole, as counsel wants.
You're over your time, Counselor.
Thank you. We would ask that it be reversed and remanded.
All right, thank you both very much. Well-briefed, well-argued case. We're going to stand in recess till 10 o'clock.
Rise.